actual live human going, there's traffic jam here, guys, you know, go that way.
We have to rely on the government for these same tokens for which we value decentralization and, you know, autonomy and those sorts of factors. Does it go against the principles that we hold dear in the blockchain space? And that's a question that people really have to ask themselves. And that's not to say that securities laws are not well-intentioned, because they are well-intentioned. But at the same time, we're all involved, or many of us are involved in this space because we can take hold of our own destiny and not have to rely on others. But as a result of securities laws, there oftentimes may be that requirement for government oversight, regulatory oversight, and those sorts of things.
Yeah, and I think just one final point in terms of the implications for blockchain businesses that are required to comply with securities laws because the token that they're offering is considered a security. Probably the biggest implication is that those tokens are not freely transferable. So like we mentioned, you need a prospectus or you need to be relying on an exemption. You can't just have those tokens on an exchange like Qcoin or Coinbase or whatever it is, and they can't just be transferred to just anyone. You need to make sure that they're either transferred by a prospectus, and if you don't have a prospectus, then to an accredited investor or some other exemption to the prospectus rules. And so that's kind of incompatible with a lot of these blockchain businesses, which are intended to have a freely transferable token in order to actually serve the utility that it's intended to achieve.
Okay, at this part of the presentation, we're going to talk about the financial instruments that securities laws apply to. Under the Securities Act in Ontario, bonds, debentures, certain enumerated terms are classified as securities. But also we have the investment contract, which is intended to be a catch-all. And typically it's the classification of investment contract under the Securities Act that most digital assets which are classified as securities will agree with. So it's important for us to go through the definition of investment contract and understand what that means.
Right, so I mean, I think the point here is that if you fall under one of these definitions, securities laws apply to you, right? And so that means the entire securities law regime, which we just spent time talking about, also applies. And so there's all these enumerated provision, bond, debentures, notes, or other evidence of indebtedness, shares, stock, unit certificate, etc., or anything that's commonly known as a security. But I think the one we want to highlight, which Ahmed mentioned, is an investment contract.
Yeah.
So there's no definition of investment contract under the Securities Act. And we have to actually look at the case law to determine what it means. But effectively, as he mentioned, it's been used as a catch-all to cover novel financial instruments. And notwithstanding that the test for an investment contract was developed in the 1940s, it's still being used today. And so that takes us to something you might have heard about called the Howey test. So the Howey test is effectively the test for determining whether an investment contract exists that was developed in the United States back in 1946. So what happened in that case was there was a hotel in Florida, and vacationers from the East Coast were attending this hotel in Florida, and they're enjoying their Florida orange juice, and they're just sitting on outside enjoying the weather, and they're thinking, we would love to own a piece of this land here. So lo and behold, there's a poster at the hotel that says you actually can own a piece of this land. In fact, you can own a piece of this land and it may be profitable for you because you can grow oranges on the land, and you don't even have to have any prior experience growing oranges. We'll grow the oranges for you. We'll pick the oranges. We'll harvest the oranges. We'll take them to market and sell the oranges. And by the way, we'll give you some of the profits at the end of the day. All you need to do is sign effectively this contract that comes along with the land. So purchasers, as I mentioned, they had no prior experience harvesting. They weren't farmers. They were just vacationers in Florida, and they entered into this service contract, which effectively gave all the control over the pieces of land to the hotel management company. So the court actually they looked at the entire agreement. They didn't just think, oh, this is a real estate transaction. They looked at the entire arrangement in the context, and they looked at the facts and circumstances behind it and decided that, well, in actuality, what this is a contract, transaction, or scheme whereby a person is investing his money in a common enterprise and is led to expect profits solely from the efforts of a promoter or a third party. So this actually became known as the investment contract test, and it's still being used today. You actually go through 4 elements. If there's an investment of money, you're in a common enterprise with the promoters, with an expectation of profit, and there's reliance on the promoters or third party. So this is the landmark decision in the U.S. that everyone still refers to today, and it was adopted in Canada by the Supreme Court of Canada in the Pacific Coast Coin Exchange decision. So that happened in the 70s, and they actually took a more aggressive stance than the U.S. Courts did, because they actually, taking the investor protection purposes of securities laws, they actually interpreted the test even more broadly than they did in the United States. So to sum it up, there needs to be an investment of money in a common enterprise, but in Canada, the common enterprise means that the fortunes of the investor are interwoven with and dependent upon the efforts of those seeking the investment. So common enterprise doesn't really help us, but they've kind of given us some background to what that actually means. There needs to be an expectation of profit, and the profits need to come from the sole, primary, or significant efforts of those other than the investor. So in the U.S., the profits needed to only come from the sole efforts other than the investor. They've added sole, primary, or significant efforts. So you see they've actually broadened the test, and the reason for that is, as I mentioned, to further ensure that the investor protection mandates of securities laws are met. Interestingly, so the Supreme Court of Canada is, there's a panel of judges. Whenever you have a panel of judges, there might be a minority opinion if you don't have a unanimous decision. So Supreme Court of Canada decisions where there's a minority opinion, the dissenting judge who has the minority opinion will sometimes put out their ruling as the reasons for their decision. So in this case, there was a ruling by the dissenting judge. And it's interesting because they actually said that we need to be careful when we're dealing with the investment contract test to make sure that it's not overly broad, so that it doesn't capture things that are not actually intended to be regulated by securities laws. So in the context of blockchain, in the context of cryptocurrencies, there's a question as to whether or not this is something that was actually intended to be regulated by securities laws. You can see that the dissenting judge in this case, which was actually Chief Justice of the Supreme Court of Canada, was quite forward-thinking in his views in sort of calling out this criticism. So, I think that sort of gives you a background on the investment contract test, but now we want to talk about how you apply the investment contract test to a token offering or an ICO.
Yeah, so that investment contract test is it's very important. Oftentimes, if a digital asset is considered a security, it's on the basis of being an investment contract and not ticking all the boxes, but when you consider that test, that will be a primary factor in determining if something that you're dealing in is a security or not. So the first part of that Howey test is an investment of money. So this one is pretty simple. It's a pretty low bar to pass. It has to be money or some clear value exchanged for the token. So, if an ICO occurred and you had to exchange your Ether or your Bitcoin for this digital asset, then some value was exchanged on your end. Or if you had to exchange fiat money, Canadian dollars, US dollars, then that part of the test is satisfied. On the other hand, if you get an airdrop or if you mine the tokens, then that part of the test may not be satisfied. Anything to add, Zane?
Yeah, so it just, I mean, so an airdrop is effectively, so one of the purposes of an ICO is not just to raise capital, but also to disseminate the token. The reason is because you want to create a user base, you want to sort of kickstart the network, and in this day and age where everyone does an ICO, you almost have to somehow disseminate the token in order to compete with these other platforms. So an airdrop is a way to do that without raising capital, because what we'll see as we go through the test is securities regulators in the US and Canada look at capital raising in a negative light in terms of whether or not securities laws apply. If there's a capital raising element to the ICO, securities laws will typically apply. So that's, the airdrop is one way to kind of get around the first prong of this test.
And this test, like, these factors aren't determinative. You know, you have to look at the situation based on its substance to really make a determination. You may have received a token through a bounty program and not paid anything for it, but promoted it somewhere for others to buy. In that situation, you know, this factor that it was given away to for your efforts, you didn't have to pay for it, may not lean in favor of not being classified as security. So you have to take a thorough and comprehensive look at the offering to really make a determination. Okay, the next factor from the Howey test is in a common enterprise. So if you get a digital asset or token, you know, through an ICO, and the tokens are given to you before the platform is released, that shows that there's more likely to be a common enterprise because you're relying on the developers, you're relying on the team to produce the platform. And if they don't, then essentially you're holding nothing in your hands. So that satisfies, or that is more likely to satisfy the common enterprise part of the test.
Yeah. So when you think of all these offerings that you've probably heard of, where people are just releasing a white paper and they're raising $100 million based on that white paper, they don't actually have a platform that's available. That's what we're talking about.
Create value, whereas otherwise it might not exist. So again, you have, you know, there exists a common enterprise where you're relying on the efforts of these individuals to really generate some value for you with the token, whether not only, you know, financial, but to be able to use the token maybe for a product or service, etc.
Yeah. So I think the point here for the second one is just, if there's a capital raising element, it taints the offering. On the flip side, if you actually are selling the token for a profit, like a sale of a product, just like how you would pre-sell any product, or I mean, not even pre-sell, but just sell any product, that is less likely to constitute a common enterprise. Yeah.
And more obviously, you know, when there's a private or centralized blockchain, then there is a common enterprise with the people who control the private blockchain. When it's fully decentralized, that factor isn't really met, because the common enterprise isn't with other, you know, quote unquote investors, but with the people who want you to invest. Another factor is the value of the token is derived from the skills or expertise of management. I know this is getting repetitive, but again, you're relying on them. So if you're relying on them, then you're in a common enterprise, and your fortunes are really based on what they're able to develop.
Yeah. So on the flip side of that, if you've got a token that's actually obtains its value based on its unique characterizations or characteristics. So an example of this would be CryptoKitties. you've got a non-fungible, not interchangeable token, CryptoKitty, with its unique features, unique cats effectively with different features, and they derive their value from the features of that cat. Same way, if you have a token that is non-ambiguously related to a physical asset, so you can actually link those two together, that's not fungible. That's not something that you can just exchange for any other token. So in that way, there's not a common enterprise created.
Because you're not relying on anyone. It's your token, and its unique characteristics may define its value, not the people who promoted or developed the platform. Tokens pre-mined and retained by promoters. Again, if you're in a project where the people who developed it hold a large amount of tokens, that again, hitches. You're relying maybe on the value of these tokens to increase and determine your fortunes. Comparatively to a project where the promoters or the people who created the project don't retain tokens, there's no common enterprise because their fortunes aren't linked to yours as it relates. And the last factor I'll speak to is the returns are paid equally pro rata to all the investors versus benefits that accrue to you based on maybe the effort you put in. Say you're getting tokens because you're providing a storage space for the project, and your returns and your benefits are based on the effort to constitute a common enterprise because it's based on your effort rather than typically just holding these tokens and relying on maybe the promoters to do a good job and provide you returns that are based on how much you've invested.
Great. Is that there's an expectation of profit, and I'll run through these pretty quickly because I think you guys have heard some of this already, but if there's a token sale prior to release of the platform, there's an expectation that that's probably going to go up in value once the platform is developed. Token as an investment and targeting persons that aren't exactly expected to use the product, then that implies that there's going to be some profit or it's speculative in some way. But on the flip side, if you're promoting the tokens solely based on their utility, there's no creation of an expectation of profit. If there's a secondary market, so if the tokens are traded on an exchange, that implies that there's going to be a market, that they're going to be liquid assets, and that is also going to create an expectation of profit. Whereas if you're restricting the operability of the token on secondary market exchanges, or you're not making any statements saying that we're going to get it on exchanges, you can argue that there's no creation of an expectation of profit. If you put restrictions on participation, so if you said that you can only participate if you've shown that you actually have an interest in the platform as it's intended to be used. So if you're using the example of where there's actual storage space, where you're providing storage space, unless you show that I've got this storage space available to me and I intend to offer that storage space, you wouldn't be able to participate. On the flip side, so if there's no restrictions on participation, then that shows that it doesn't really matter if you use it for its intended purpose, and that shows that it's more about creating an expectation of profit. So if the token has a purpose of speculative investment, or if it has security-like features, like if you've paid a dividend, again, expectation of profit. If the primary purpose is some form of utility, then the argument is that there's no expectation of profit created. If you limit the returns to token holders, so if you say that everybody can only invest $1,000, let's say, or there's some other small amount of tokens, that shows that you're trying to limit the creation of an expectation of profit. Whereas if it's unlimited and anybody wouldn't be able to use those tokens for their intended purpose, then that's a good argument to show that there is no expectation of profit. And then the last point is that there's reliance on others, and there's a lot of overlap here with the ones that Ahmed was talking about. But I mean, I think the point here is, again, if you're relying on the efforts of somebody other, of the actual promoters. So where there's off-ledger action required in order to get the benefit of the token, that's going to be a situation where you're relying on an intermediary. So, you know, if you think about the transfer of physical assets are probably not going to be represented on the blockchain. Some other custodian or third party has to actually affect that transfer. So you're relying on that third party. That shows that there's reliance on others. Again, I mean, I think a lot of the points were already covered, but I think one that wasn't really talked about was if the value of the token is likely to fluctuate versus if the value of the token is fixed. So if the value of the token is tied to, let's say, a physical asset, let's say the US dollar, there's no reliance on the promoters to actually make that go up in value. So again, that would be something that would be more favorable from this prong of the test. And as Ahmed mentioned, it's really a contextual analysis. If you're thinking about doing an ICO, you'll have to think about all the different factors. There's a lot of hoops that you have to jump through. The regulators have provided a lot of guidance, but the point is, you can't just say that a token has utility and expect the regulators not. You have to actually ensure that the token is intended not to create an expectation of profit. You're not marketing it as such, and that it actually provides a utility is important to the actual platform. Again, you can contact myself or Ahmed if you have any questions about any of that.
I'm not a securities lawyer, but you can contact me if you want to discuss any of this, just this conversation.
Yeah. So that concludes our presentation. If anyone has any questions, feel free. I know it was a lot to digest, and it was mostly focused on parties who are blockchain businesses that are considering ICOs.
Yeah,
but
it does have implications. You know, if you're considering getting an asset, you want to know, is this a security? Those factors would be useful to you.
Any questions?
So at the beginning of the presentation, you mentioned that this is relevant to Ontario. I was wondering if it differs from province to province, and then more importantly, globally, if is this something that you see in most countries, or is it mostly in maybe Western countries, or does this compare globally to other markets globally, worldwide?
Great question. So, I mean, as you recognize, because of the global nature of these token offerings on a global scale, the jurisdiction is a huge issue. So the question amongst the community is, which jurisdiction, the securities regulators in which country, effectively, are you supposed to look to follow the rules for? So generally speaking, when this is a very quickly developing industry, the regulators in all different jurisdictions have come out and said some investors about the dangers of ICOs because of the reasons we mentioned. There's been so many scam coins out there, and for the most part, I would say that they're aligned with one another. Now, there are jurisdictions that take a less aggressive stance, and there are jurisdictions that take a more conservative stance. The U.S. and Canada are jurisdictions that I would put on. They're a good sort of marker for people who are thinking about doing an ICO. If they comply with the most conservative jurisdiction, they're probably good in all of the other jurisdictions. There are other jurisdictions that are considered more favorable. Like, I mean, I think Switzerland is one that Valley is what they're calling Zurich in Switzerland. So there are also Cayman Islands and other offshore jurisdictions which are considered more favorable. So there is some jurisdiction shopping that happens, and especially because of the conservative nature of the U.S. and Canadian regulators, we have seen Canadian and U.S. in the jurisdiction what's known as a brain drain. We see some of these innovators going to more favorable jurisdictions in order to set up because they're more favorable to crypto. So there are differences in the jurisdictions, mostly aligned. To summarize your question, mostly aligned, but the safest approach is always to comply with the most conservative jurisdiction.
raising capital, why do people pick ICO over IPO?
Right.
Like, is it easier?
Great question. So, yeah, I mean, I think the point is, like, when you do an IPO and you're issuing a prospectus, we kind of alluded to this, but there's a huge cost associated with that, right? You have to make sure that you comply with all these rules and regulations. You have to make sure that you provide the necessary disclosure. So you have lawyers and auditors and financial advisors working to make sure of that. I mean, you're looking at a huge bill in the 7 figures, right? To do an ICO, like when it first came out and it was, you know, something that nobody really knew about, nobody really understood that securities laws applied, you could pretty much do one with just an idea. That's what people were doing. Now, obviously, there were offside securities laws, but people were now, if you were to try to do an ICO on, you know, that's considered legit, that complies with securities laws, you would still be spending less than you would be spending for an IPO. But I mean, I think the better comparison is probably if you should go it's mostly startups that are doing these businesses. So you really should look at whether it's better to go with a venture capital financing or to go with an ICO, right? Because VC is more typically the people that you see or the funds that you see investing in early stage companies. Now, the issue with VC funding to impose restrictions on the business, they want their advice to be heard. They want to have some control over the business. And a lot of entrepreneurs don't want to give up that control. They don't want to give up any of their equity. So the ICO was really a way of, you know, obtaining more favorable funding than what's otherwise available through more conventional methods.
And I wanted to add, you know, there are advantages of, you know, DLT, digital ledger technology for settlement. There are projects right now who do think that using the blockchain to a good idea because it may be quicker and faster and cheaper. So. Yeah,
that's right. So, I mean, with IPOs, you're involving a number of intermediaries. Like I said, it's expensive. With an ICO, I guess the idea is that you would be involving much fewer intermediaries, and it would allow for shorter transaction times and have all the benefits that another blockchain type business would also have.
I have a question regarding the ICO legal structure. Okay. So, of course, now you mentioned the security law start to get involved. So ICO launched in 2017 are very different from the ICOs. There will be companies set up offshore, have a Canadian operation or US operations. There will be ICO set up to have a geo block. So as of today, geography block to not just set to any Canadian, Chinese, or US citizens due to security law reason. Right. So my question will be, as of today, there's no clear regulation come due in order to issue security token. But per your understanding for the ICOs you work with, what will be the right way if you are a Canadian ICO company and want to issue security token?
Right. So if you're issuing a token as part of an ICO where you recognize that the token is a security, there's actually like a prescribed way of doing that under our securities rules, right? It's just it's a securities offering. You would have to, if you want to offer to the general public, file a prospectus, or if you want to offer to accredited investors, you would be relying on an exemption to the prospectus rules. So I mean, there's really not an issue at all if for some reason, based on maybe the structure of your platform or what your platform is intended to achieve, you need the token to be freely transferable, and you're not willing to go the route of filing a prospectus, so you don't want it to be characterized as a security, then there's a lot more sort of nuances and things that you have to, we were talking about, all those characteristics we were mentioning of when you would and wouldn't be considered, you know, or what the features of an ICO that would militate for and against it being treated as a security. That's when you have to consider those. So there's no real, there's no real right or wrong way of doing it. I mean, it just depends on what your motive is, if you're in securities laws or if you're trying to sort of create a token that is not considered a security. Does that answer your question?
Yeah. Yes, I just want a little more detail about that. So what is the path actually to take advantage of an ICO, because ICO, so you try to do something faster than you get with the venture capital.
Yeah.
You may consider there is a lot of money there which you could take advantage. So let's suppose you actually try to do a product which actually do a service and actually do something useful. How you can do that? Do you have to actually go OSC and say, hey, do you like that? Don't you like it? Because you don't want to do it, and they ask you, no, don't do it that. Because everything you told us now was don't do. But we should have a path to do that in a way, to take advantage of that.
Great point. Backtrack and say, I don't think we're saying not to do anything, and in fact, the OSC is definitely not saying that either. I think what they're really saying is to carefully consider what you're doing, right? So there are ways to go based on what the guidance that we've been provided. There are ways to go about doing an ICO, either complying with the securities law regime or to make sure that you're not creating an expectation of profit and you're not sort of hitting all the features of the investment contract test. Now, to your point about doing an ICO is faster than the VC route, I would respectfully disagree with that. I mean, I think part of the reason is because what you mentioned is you need to go through the regulators in Ontario, at least, through their program. So the regulators actually have, in each of the jurisdictions of Canada, they have it's a program through which you can engage with the regulators to talk about how you can bring your platform to market and comply with securities laws. So this is a discussion that you have with the regulators, and in time there is some delay to that. So, and because it's a quickly developing area, there is also some delay built into that as well, as changes to the law happen all the time.
Check 1 2. Hey everybody, welcome to Crypto Bay. We're going to start momentarily. Help yourself to the pizza. I don't know if there's any brio left, but you know, it's not often you get the soft drink of Italy for free. You know what I'm saying? Okay. Am I on here? Oh. Okay, Dennis, you ready?
Yeah.
Okay, we're getting ready for Crypto Bay. Dennis taking a selfie. Okay, we're going to get into how to use Bitcoin today. It's going to be great. Apparently you can buy Kentucky Fried Chicken. I mean, sorry, KFC. We're not allowed to call it chicken anymore.
It's not chicken?
It's not chicken. Okay, Chris, we're on. This is Crypto Bay. We're not changing it. Welcome to everybody who came here tonight. Downtown Toronto. Nice hot night. If you want to participate in this conversation,